All right, the next case that we have on the docket is Seufert versus Garris et al., case number 20-2646. Well, have a safe trip home to Fort Lauderdale.
Thank you.
So when you have the option for Zoom, do you bill your client for travel? All right.
Yeah, you had the option.
Yeah. Well, yeah, we're going to be better about letting people know that after the first of the year. It's going to an order will go out after an oral argument request, letting people know that. That's one of the questions I asked when we started, was whether people were aware of that, just to see. And that's we could have done perhaps a better job in these cases, but there are only a couple of them, and we're going to start that in January. So I apologize for that, but here we are. So we're all good to go. All right. Each side will be entitled to 20 minutes each. We have a default 5-minute for rebuttal. If you'd like something different than that, let me know, and I'll be glad to accommodate you with that. If you have any electronic devices, cell phones or others, please make sure they're on silent so that we don't interrupt the flow of the argument. So that said, Counsel, if you're ready to proceed.
Thank you, Your Honor. May it please the Court, Paulino Nunez on behalf of the plaintiff and appellant, Mr. Seufert, or Deputy Seufert. And as the Court, I'm assuming, is aware,
He's here in his capacity as an individual, not as a deputy.
I'm sorry, sir?
He's here in his individual capacity. It's not capacity as a deputy. So
Absolutely. It's
right.
a personal claim. There's nothing about his official capacity. But the only reason the official capacity is relevant is because he's a member of the Florida retirement system, as are Your Honors and most other Florida employees. In any event, the claim here, it's our appeal for dismissal of the complaint. This was a pure dismissal on the pleadings. There's no summary judgment, no facts, and
let me ask this: the damages in this case flowed from the disability, not from the representation that he could have switched back to the pension plan from the investment plan, correct?
I'm not sure that I understand the question for this reason, Judge. If he would have been able to switch back to the pension plan, then he would have been able to give his daughter that disability benefit.
But the specific damages are what it cost, the disability. It's the amount paid for the disability is really what the damages were, correct? Yeah,
and it's really not for it's a joint annuity. The only reason the daughter is eligible and is eligible essentially for life, because
upon disability,
is based on her disability, correct? But it's not directly disability in that sense. In other words, the defense keeps pointing out, well, Mr. Seufert's alive. In theory, he could live. His daughter has a normal life expectancy. She's 13, 14 now. In theory, I mean, I saw the other day, 3 sisters, each of them 100 years old. In theory, they could live to the same age, and the daughter would never kick in as have a separate benefit, but the father would continue to have the benefit and could certainly use that to support his daughter.
But it's undisputed that Mr. Seufert is it Seufert, am I pronouncing that right?
Yes, I believe so, Your Honor.
All right, Mr. Seufert didn't know of the child's condition at the time that he met with Garris, correct?
She had not been diagnosed. I think they had some, they were concerned about her, but she had not been diagnosed with a disability. It's a form of autism.
As a result, then, it's obvious that Garrett had no knowledge of the child's disability.
That's correct, Your Honor. And we're certainly not alleging that Mr. Garris or the Nelson firm knew that she was disabled.
Okay, but the cause of action sounds in fraud.
Yes.
And how can there be fraud when he wasn't aware of the disability?
Right.
How can that constitute fraud?
It's constructive fraud, and it's knew or should have known, and it's recklessness, Your Honor. And the point is, what they said to Mr. Seufert was not, oh, if you get this, you're going to have disability. They didn't say anything about disability benefits, but they said to him, he came in and he said, I am very concerned about my family's financial.
Oh, but that's a general, that's what people invest for. They invest for, for their own benefit and for the benefit of their heirs, and that's just a general concept for everybody would have.
Sure.
That's why you invest. And so I'm trying to understand, how that can even constitute a constructive fraud.
Because if they had told Mr. Seufert, you're concerned about your family, you have a young child, you should know the pension plan has benefits, including disability benefits for children that are not available in the investment plan. There was no discussion of these distinctions.
But why would you? Why would anyone in the normal course of going over, whether you're going to go from a pension plan to an investment plan, you think that that's a normal question that would come up in the course of those discussions?
If you're telling somebody, you should switch to the investment plan because this is so much better for you, for your family, essentially in all circumstances, and by the way, you should do it immediately, you should do it now.
All circumstances. They're not saying, nobody is talking in terms of all circumstances. You're talking, generalities, that if you switch to this, we can do better with an investment plan than the state does with a pension plan.
It actually doesn't quite work that way because...
That's not, I understand that. That's
Right.
a different issue.
Okay.
You're not making claims that, that the investments were mishandled or...
Correct.
That as a result, he got less money through the investment plan than the pension plan. That's not what the cause of actions is.
That's correct. Your Honor, the point is, had they told this gentleman, in addition to these investment benefits, which we say are significantly better in the investment plan than in the pension plan, there's also this additional benefit in the pension plan that you're giving up. So you should know when you're comparing, is this a better plan for your family or not? You need to know.
Because of an unknown disability, a disability of a child, unknown to the person that's in the office talking about what they need and what they want, and is unknown to the person giving the advice, that they should have anticipated that.
Yes, Judge. If he's...
Best case you've got to support that proposition.
Your Honor, again, if you're telling somebody A is better than B in all...
Best case law that you've got to support that proposition. What's the best case you can cite for that proposition of law?
Judge, it's a false statement, a material statement to the client to tell...
Asking for a case. Florida case law.
Right.
I'll take federal case law.
Judge, I don't have a case that specifically addresses that issue. I have general cases on fraud and material misrepresentation and failure to disclose. Omission, fraud by omission is absolutely recognized under Florida law. And that's what you have here. You have an omission. You're telling somebody this is better than that, but you're not telling him that the pension plan has this added benefit that's simply not available.
How do you get around the statute of limitations issue in the case?
Well, if it's fraud or constructive fraud, there's a discovery rule, and the pleading...
You should have known, and this isn't a question of fact, this is a question of law, really. It's the legal impact of this provision in the changing from the pension plan to the investment plan.
No, because if you look, if that's the standard, then you're dealing, when you're dealing with a fiduciary relationship, and that's what we're alleging existed here, the fiduciary has, the beneficiary of this relationship here is relying on the fiduciary. The fiduciary has an obligation to disclose. It can't say, well, you should read 5,000 pages or 500 pages, whatever, in the Florida statutes. You should read hundreds of pages in the Florida statutes, and you would know somewhere in there it says there's a disability benefit, but not on the other case. That's not the law. Then you would never be able to rely on a lawyer, you can't rely on an accountant, and you can't rely on a financial advisor for something like that, which is not obviously known. It's not, like, they cite this case, GLK. It's, first of all, that's an arm's length transaction, securities purchase, and the court said, you should have known when you signed this that this was a certain specific type of transaction you entered into. This is not what's going on here. There's no sale here from the financial advisor. The financial advisor is providing advice, and he's saying this plan is much better for you than the other plan. And he doesn't say, by the way, this plan that you're giving up, which he tells the client, our client, that he's not even giving up anything because he could always go back if he wants to. And
I understand.
Right.
Is it your position that he would have an obligation, every client that he talked to talk about, well, you know, you're going to give up disability if you have a child that's, you know, disabled? You think he's got that obligation in every case to everyone he talks to?
I would contend
that representation.
I'm sorry. I would contend that if he is everybody that he's saying, hey, you should switch, and you should switch now because this is better than that, I would contend that yes, he has an obligation to explain the circumstances that could make the pension plan actually remain better than the investment plan, even if everything else he said was true. Now, if he's not convincing him, if the client just comes in and says, hey, I've heard about this investment plan, I think it's great, I want to go there, I mean, first of all, he doesn't have to go to the advisor for that. He could just sign the form on his own. He comes in for advice, and the investment advisor says, well, in your circumstance, it's obvious you need to be in the investment plan because you're going to be so much better.
Does your constructive fraud claim, is it dependent upon him being a fiduciary?
Yes, sure, yes, that's the only...
So if he's not a fiduciary, because they had no prior relationship, this is the first, you know, they meet that day.
That's true.
So if there isn't that relationship, does your constructive fraud claim fail?
Yeah, absolutely, that's one of the elements.
And you would concede that there's no direct fraud?
But fraud by omission, but other than fraud by omission, no, fraud by omission is recognized in Florida law. But as far as is he a fiduciary? Yes, Judge, it's the same thing. If I'm a lawyer, somebody comes up to me and asks me for legal advice, I don't charge them anything, but I know the guy's going to act immediately on that advice. I better do it right or tell him not to act on it.
Are there investment folks that are fiduciaries and those who are not? Or is, in your view, is every financial advisor a fiduciary?
No, there's different, there are fiduciary investment contracts, and you can have a contract with the sales agent, I would call him a sales agent.
You would agree that not every investment individual advisor is a fiduciary?
Yes, and certainly if this advisor, Nelson Garris, had told Mr. Seufert, buy A instead of B, I would not contend that was a fiduciary transaction.
What makes Garrett a fiduciary as opposed to other financial advisors who you concede are not necessarily fiduciaries?
It's the nature of the reliance by Seufert. Seufert comes in, he's going to make a decision, a life-changing decision, although he doesn't know that it's a life-changing decision. The fiduciary should know that and should explain to Mr. Seufert, this is a potentially life-changing decision. Before you make it, you should know all these facts. If you want, then once he lays out all the facts, then you can't say that Mr. Seufert was relying on the knowledge. But when he withholds some facts, he just tells them it's better. He doesn't tell them, oh, but there's this little side thing here, which doesn't come up very often, but hey, every once in a while somebody has a disabled child and it would have been a dramatic difference, but we don't have to mention that.
Was that a fact, or is that just provisions of the contract with the pension plan versus the investment plan?
A fact? I'm not sure the question, Your Honor.
Isn't it, what you're asking to do is to go through the provisions of the statute that govern the pension plan and say, well, it's got this provision, this provision, this provision. Isn't that what you're requiring them to do?
No, well, I'm not saying, there's many provisions in there. I'm not saying that all of them are significant.
Well, but how would you know?
Because, Judge, this is a very specific provision. There is a benefit in the pension plan, which basically doesn't exist outside of the FRS pension plan. I don't think you can get that benefit. You can't go and buy a joint annuity for yourself and a daughter or a son. You can't do it. I don't think anybody would ever sell that to you. This is something that is, in effect, a hidden benefit.
Okay.
And if you're telling somebody the investment plan is so much better than the pension plan, yes, he's got an obligation to say, when you're considering whether the investment plan is better than the pension plan, you should know there are these particular benefits in the pension plan that you may not know about. Most people don't know about them. I've met hundreds of people who are employees in the FRS plan and weren't aware of that pension benefit being in there.
I can tell you, I wasn't aware of it until this case.
Yeah, but it exists, and it's a very valuable benefit for those people it exists for. And if you are a professional, you're representing yourself as a professional, and you're not disclosing that, because if you're not telling the person to change, or you're laying out the facts, then at that point there would not be this fiduciary relationship. But when you say trust me, and you don't disclose all the facts, I think you are responsible for those facts you failed to disclose, which is what happened here.
Was the child diagnosed with a disability within the 4-year statute of limitations period?
Well, what she has is a form of autism, and she was diagnosed, I believe, at 2 or 3 years old is the earliest that they really diagnose that. And in her case, it's a severe form, and it's something that she would not be able, every indication that she would never be able to support herself.
But there's nothing in the record that once the diagnosis happened or was confirmed that Mr. Seufert met again with the defendants about this particular issue or met with another advisor about this issue.
No. There's no allegation. Remember, this is a dismissed complaint. There's no record except the complaint. But there's no allegation about that. But we certainly do not contend that they went back to discuss this with Mr. Garris.
It was just after 10 years, he was ready to retire and then realized that
when he went to retire, he found out, I can't switch back to the pension plan, and oh, wait a minute, there's this benefit I didn't even know existed.
Counsel, you are within your rebuttal time if you'd like to reserve.
Yes, Your Honor, I would like to reserve.
All right, thank you, sir.
Thank you.
May it please the court, I'm Ken Hazuri. I'm here for the defendants and the appellees, Joel Garris and his affiliated investment advisory and brokerage firm.
Was Garrett a fiduciary?
No, not in this situation, Your Honor,
Then,
for all the reasons that you basically pointed out to Mr. Nunez.
Well, let me hear your argument on why he was not a fiduciary.
The argument as to why he's not a fiduciary is because this was a first-time meeting. They had no prior relationship, and they have no contract between them. There's no brokerage or investment advisor relationship, and that is not the type, and we all agree that there's no express fiduciary relationship because there was no investment advisor relationship, there was no securities brokers relationship, or any type of relationship that would give rise to an express fiduciary duty. So we're down to an implied fiduciary duty.
Do you admit for purposes of our consideration that Garrett represented to Mr. Seufert that he could switch back to the pension plan?
Well, we have to admit that because it's pled in the complaint. we don't admit that in reality, but it's in the complaint.
All right, and that would be a misrepresentation if it indeed were true.
Yes, if we accept as true that Mr. Garris said at the original meeting in 2007, then that if you switch from the retirement plan from the pension plan to the investment plan, and he said to him, and you can switch back whenever you want, that would be a misrepresentation. not saying it's necessarily a fraudulent misrepresentation, it would be an inaccurate, incorrect statement. Okay. Going back to answering your question about the implied fiduciary duty, I think this case falls directly under the Building Education Court versus Oceans Bank case, cited in our brief, 982 Southern 2nd 37. It's a third DCA case where a developer had extensive meetings with a representative of a bank to possibly get financing on the proposed development, disclosed confidential plans regarding the development and what have you. And then the developer went into default on another loan, and a vice president of the bank came in and foreclosed, was a part of the group that bought the property out of foreclosure and then developed it. And the plaintiff alleged, the developer alleged that there was an implied fiduciary duty there. And examining that, the court first noted, however, during the entire period of Gutierrez, who was the developer's interaction with Ocean Bank, neither she nor Building Education was a depositor or customer of Ocean Bank. And she's meeting with them repeatedly, relying on them for advice, trying to get guidance and what have you, the same type of argument that's being made here. And then it says, getting more to the holding of the case, again, we're still on Building Education Corp. While a contractual relationship between the parties is not required to form a fiduciary relationship, a party must be under a duty to act for or to give advice for the benefit of another upon matters within the scope of that relation. Goes on to say, in this case, Building Education was only a potential customer of Ocean Bank. Building Education was not a depositor, borrower, or trust department client. And by the way, duty in that passage that I just read is highlighted by the court, and potential customers highlighted by the court. In this circumstance where Deputy Seufert had never met Mr. Garris, went to him willingly to ask his advice, because as pled in the complaint, other officers had...
How do you go to an investment counselor unwillingly?
Well, fair, sure. I can imagine a situation, but you make a fair point. He went, but my point is, well, I would say this goes also to another, let me finish my thought here. So he went to him, had one-time meeting, got advice from him. There was no duty within that meeting of Mr. Garris to advise him. There was no relationship that would give rise to a duty, okay? And he was a potential client of Nelson and Mr. Garris, not a signed client. So I think it falls right under Building Education Corp. The issue that you point out, Your Honor, that he went willingly, and when would he ever? Maybe not in this situation. I can't necessarily think, as I'm standing here with limited time, of when you would go to an investment advisor, anything other than willingly, but it goes to the dependency element of an implied fiduciary duty relationship also. In all the cases where you see that implied fiduciary duty was found, you're dealing with, an 81-year-old widow in the Crucell opinion that you wrote, and a much younger man who was assisting her with things and providing support to her and was like a son to her. That's more of a dependency relationship than a willingness type relationship. In the Harold case, it was a...
I really hate when you cite to us opinions that we've written.
You said you hate that?
I hate that.
Yeah. For some reason, I thought you might like that. I don't know where I got that idea from.
Maybe it's just me.
But the point being, in an implied fiduciary relationship, when you find them, it's a long-standing, trustful relationship where people, there's different power structures and what have you, and a degree of dependency arises. Because he went willingly, because officers told him that they were giving advice, I don't think that degree of dependency is there in this case.
I went to Fisher Investments, and I met with them the first time. Do we have a fiduciary relationship?
Did you sign up while you were there?
Advertise it on TV. They say we're a fiduciary.
Well, I think Fisher, that's one of their, that's an interesting point. I think actually that becomes not an express relationship, because I think what Fisher is selling is we will take on the obligation as your fiduciary when you come to meet with us, and that's different than what other brokerage firms go. So my understanding from that ad campaign is that it would be right in the contract, that we're your fiduciary, we're not just here as your brokerage firm making stock trades for you, I think is what Fisher's selling in that situation. But Your Honors, there was no fiduciary relationship in this case.
Talk a little bit about the statute of limitations.
So the key point about the statute of limitations, a couple of them. One, as you noted, these are legal issues that arise right out of the law, and you have to look at the language of the statute that was followed in the GLK decision. The statute says that the cause of action accrues when the facts giving rise to the cause of action are known or should have known, not the cause of action itself, when the facts giving rise to the cause of action. And the GLK case makes that very clear. As you've heard over and over again from Mr. Nunez, we disagree with the theory and with the generality that, as you noted, Your Honor, to say, well, it's going to just be better under all circumstances. That's not actionable. But when you hear that from him, what he's saying is the whole cause of action, all the harm, supposed harm, arises out of the switch from the pension plan to the investment plan. And he knew that on the day he signed the form, that that's what he was doing, that he was, whatever rights he had in the pension plan, he was giving up to go into the investment plan. And so those are the facts giving rise to the cause of action. He gave up those rights, which he says he shouldn't have given up.
Could it also be interpreted that it's when he becomes aware that the child is autistic, that's the operative fact?
I don't think so, Your Honor, because again, he gave up the rights under the pension plan, whatever those rights were, and that's what his cause of action is, based on giving up those rights.
Because he couldn't have switched back.
Well, that, as we said in our brief, that made the alleged damage, we don't believe he was damaged, but that makes the alleged damage irremediable, because you can't switch back, but it's not what actually causes the damage. It's the loss of the rights, which he gave up immediately upon signing the form in November of 2007. Again, the failure to switch back makes it that irremediable. You can't switch back to the pension plan, but that's not what causes his damage. I think you posed that to Mr. Nunez in one of your first questions, and you were right on point there. That's why the statute of limitations, both two reasons. One, these are all legal issues. They're in the statutes and what have you. And by the way, Your Honor, that particular issue, the ability to switch back, is right in a Florida, the inability to switch back, excuse me, is right in a Florida statute that's cited in our brief. And so that's why Judge Munyon was correct in concluding that the statute of limitations, that the case was barred by the statute of limitations. And that's a segue to another kind of overriding issue here that touches on the issues that you were, I believe, correctly posing to Mr. Nunez about the disability issue. Just lost my train of thought there a little bit. So you were asking him about disability, and what I guess, let me take a step back since I lost my train of thought of where I was going on the segue. I think the key point in all of this, which has risen to the forefront with the admissions that were done in the briefing, in the initial brief and the reply brief by the plaintiff, is the repugnancy issue in the complaint. As we noted, the complaint specifically pleads that Garris did not have information about Deputy Sweefert's daughter's disability. And then in the initial brief, they specifically admit that it is quote unquote true that the defendants could not have intended to deceive Sweefert regarding the benefits available to his disabled daughter. That they've admitted that fact. It's crucial. And then on their reply brief on page 10, they say it is true that Sweefert was not yet aware of his daughter's disability at the time of the meeting, the November 2007 meeting with Mr. Garris. And then Mr. Nunez candidly admitted those facts on questioning from you. So where are we at on this, Your Honor? Where we are at is it is impossible for Mr. Garris to have defrauded Deputy Sweefert on the issue of disability because nobody knew about it. Deputy Sweefert didn't know about it in the meeting, and neither did Mr. Garris. So you had asked Mr. Nunez for his best cases to support his theories on that. I want to give you my best case to support an affirmance, and that is this court's opinion in Simon v. Celebration Company, 83 Southern 2nd, 826. Not just this case, many cases say this. The elements of fraud. The defendant made a false statement regarding a material fact, and the defendant knew that the statement was false when he made it or made the statement knowing he was without knowledge of its truth or falsity. As we've heard, Mr. Garris made no statements regarding disability. They aren't pled in the complaint. Mr. Nunez isn't contending that here today. He could not have possibly made any statement intending to deceive Deputy Seufert regarding disability benefits available to his daughter because nobody was aware of the issue at the time of the meeting. Okay, so there is no fraud there because those first two elements aren't there. Now, going to the issue of causation, which I submit applies both to an actual fraud, a fraud in the inducement, and a constructive fraud, okay? This court says in Simon v. Celebration, moreover, fraud cannot form the basis for recovery of damages unless the damages directly arise from the fraud and are causally connected to the fraud. Okay? There was no fraud relating to disability benefits in that 2007 meeting. We now know that beyond any question. So there can be no damages flowing from a non-existent fraud relating to disability damages, or damages arising out of the inability to get disability benefits. So, and there was, he wants to say respectfully, it was a fraudulent omission. That's kind of where he's now hanging his hat because we know there was no statement. Okay, again, you'd have to have the intent to make a fraudulent omission when the issue, nobody was aware of it, it never came up. There can't be a fraudulent omission, and there would have to be a fiduciary duty to have a fraudulent omission, and for the reasons we've discussed, there is not. So where we're at, if you want some overriding views that I've come to land on after living with this case for, a couple of years now, what they're really asking is to make Mr. Garris and his affiliated companies the guarantor of whatever happens in the future. Your daughter, unfortunately, is diagnosed with disability, or any of the other myriad of, negative things that can happen to us in life in the future. That's on Mr. Garris and them, because they're promising that it's going to be perfect. This switch is going to be perfect, and it's going to be great for you in all circumstances, as you've pointed out. That's what they're trying to do here. They are trying to hang around Mr. Garris and his affiliated companies a contingency that unfortunately arose in life, the daughter's disability, that nobody was aware of. And no investment advisor or person can have that duty imposed on him or her fairly or under the law. That's why we have the strict causation. There has to be a fraudulent statement or fraudulent omission with intent, and the damages must be strictly tied to the fraud. Think about it in terms of just buying a security. Somebody comes in to see Mr. Garris, and let's just say they even have a relationship, or any investment advisor, a securities advisor, and Mr. Garris.
A little different. I mean, I guess the theory is that he should have had. He was in a position to have superior knowledge as to the terms of the pension plan that would have allowed, the continued financial security of the daughter and disability. That he was in a position of having superior knowledge as to that.
That's how they're trying to get to a fiduciary duty, to say that he had superior knowledge. So I think it's fair to say Mr. Garris had superior knowledge on these issues of the FRS plan than Deputy Seufert. Let's assume that to be the case. That's not the sole basis for creating a fiduciary duty. Again, you have to have a duty to advise, dependency, all the stuff that we talked about. And you would also have to have, under Rogers v. Mitzi, another opinion from this court, abuse of a fiduciary relationship. Abuse, okay? The other overriding fact, this ties into the overriding concept, is on their best day, what they're here talking about is a negligence action. He didn't tell them about the disability, the benefits that would have been available to his daughter. That's something he should have done as an investment advisor, and he didn't do it, and unfortunately, Deputy Seufert later had a daughter diagnosed with a disability. He should have done it. There was no intent not to. There was no intent to mislead. You can't draw that from fact. He should have done it. On its best day, it's a negligence claim. But the problem is they're trying to fit a square peg into a round hole because of the statute of limitations.
Now
They put it into fraud to get the discovery rule.
There was a discussion about, well, you need to do this today, and this occurred, this was many years ago now, a long, long time ago, when that
Yes, Your Honor.
initial conversation or meeting took place. And he said, well, you better do this now before the legislature closes this choice. How's that gone?
So the allegation in the complaint is he should do it now.
Has the legislature closed that yet?
I'm not aware of that happening.
I'm not really aware
Me
of that
either. Let me say this. The allegation in the complaint is that you should do this now, you should do it immediately, because the legislature could phase out this option. Okay? That's a statement of a possibility in the future by a third party, the legislature, that Mr. Garris or has no control over. Some might say, you could call it
Absurd?
You could call it an aggressive statement.
Absurd isn't the word you were
Well,
searching
no,
for?
I wasn't reaching for absurd. It could happen.
all right.
It could happen, but it's not a fraudulent statement, but something that might happen in the future, could conceivably happen in the future.
Is in like the state of Florida seceding from the Union type of possibility? Is that what you're suggesting?
This day and age, who knows, Your Honor? We might watch this video sometime 10 years from now and go, well, I'm joking, of course, but it has to be a fraudulent misrepresentation. And by the way, the idea of the legislature could do this, and this is kind of important too, there's no damages that flow from the statement the legislature could do this in the future. He's just saying that convinced us to make...
That type of salesmanship.
That's a fair word, salesmanship. That's fine, and salesmanship is allowed. It's not fraud. But the point there is there are no damages that flow from a statement that the legislature could, do away with this option. It goes back.
And I admittedly, that's a little off target, because that's not what the claim is anyway, so.
That's the bottom line, Your Honor. This whole case is founded on the loss of his ability to provide potential lifetime benefits if he were to predecease his daughter because she's disabled, and nobody knew it at the meeting. Nobody knew it. And you cannot hold an investment advisor or anybody else responsible in fraud for something that nobody knew about and he had no intention to mislead, either by an affirmative statement or by omitting to say something. That is not fraud. On the best day, it's negligence. They couldn't bring a negligence claim because they beat the 12-year statute of repose under a fraud claim by a few hours, and they had to rely on the discovery rule. So that's the overriding defect in this whole case, is that, again, they're trying to fit a round peg into a square hole to get the benefit of the discovery rule under fraud. And, Your Honor, I think your questioning to Mr. Nunez was right on point, and I think you all understand the issues. If you have any other questions, I'd be happy to take them. Otherwise, we would respectfully ask that you affirm the trial court's dismissal of the complaint with prejudice. And by the way, they gave up the right to amend. That's in the record. And I thank you for your time today.
Thank you. You're good. Take your time.
Thank you. I'm sorry, I got kind of
All right.
tangled with the
Not a problem.
mask there. My wife hasn't had her third vaccine shot. I don't want to have a problem. Your Honor, the issue, yes, nobody's here trying to make anything up about what happened at this meeting. It's very clear what we're saying here. Mr. Garris, when he is telling somebody, you should switch to this plan, it's so much better for you, I know what you want, you need financial security for your family, this is how you do it now, and if you don't do it now, frankly, it's a big mistake, you're really stupid. I mean, obviously you didn't use that word, but the whole point was this pressure to do it now. That's what all these statements are, pressure to do it now, coupled with the superior knowledge that the Garris firm and Garris and firm had, and the failure to point out all the relevant facts to Mr. Seufert when it was clear, and the Crusoe versus Mong case and Quinn versus Phipps, which are cited in our brief, all talk about when an implied fiduciary relationship is created. And in this case, there's no question that they obtained the trust, Mr. Garris and the Nelson firm obtained Mr. Seufert's trust by expounding about their superior knowledge and experience in these matters, that Mr. Seufert was obviously relying on them. He told them, I'm going to rely on them. I see, I believe you, I accept this. And they abused that relationship by telling him, you should switch now. We do allege that they had a financial incentive for doing so on a broad basis, switch as many people as possible into the investment plan. Eventually, some of those guys, most of those guys, hopefully for them, are going to come back for advice when they do retire. While they're still working, they actually can't get, you can't control the investments outside the plan, but once they retire, they could take out a lump sum, and they could now be a client of the financial advisory firm with hundreds of thousands, in some police officers I've seen where it's over $1 million. And, you could get a pension for life, and that's a nice money, $80,000, $100,000 a year, but that's not going to make you a really viable client for a financial advisor. If you have $1 million chunk of money to invest, now you're a viable financial advisee.
We understand the finances of it.
Right, and so in terms of, did they abuse the relationship? Yes, when they tell this guy, do it now, and they know he's going to do it, they bring him the paper. They don't tell him, go call up the FRS hotline and get the papers from them. No. Here's the papers. I got them right here. Here's the paper. He signs. They says, I'll even mail it in for you. It was a full service, do it now. So there's no question. It's not like, I meet some guy in a bar and I said, hey, investment plan's better than the pension plan. The guy the next day switches. That's not what happened here. He goes into a very respectable-looking office of a financial advisor, and he gets this very specific advice, which has very specific consequences. We're not alleging, as I told Your Honor, we're not alleging that Garris was a general fiduciary if they bought the wrong stock or something. That's not what we're talking about here. We're talking about this very narrow point of make this one time out of the pension plan, which, by the way, they lied to him or they misled him. They told him he could switch back. That's not the case. You can't switch back. And there are these consequences that go with it, which were unknown to the client, unknown to the beneficiary of this fiduciary advice. And as far as is it connected to the fraud? Of course it is, because the fraud is the omission, the failure to disclose all these relevant facts, and the damage is that once you're out of the pension plan, you cannot get this benefit back. And I don't think you can buy it. If you can buy it, it's going to be very expensive, and that's the measure of the damage in this case. I don't know if you have any other questions. I'm basically out of time. I would ask the court to reverse. This is a dismissal of a complaint. On its face, there's nothing on its face of the complaint that says he wasn't relying. He was relying. There was a relationship, and we ask the court to reverse.
All right,
thank you very
Mr.
much.
Nunez. Mr. Nunez, I apologize that we didn't communicate the ability to have done this remotely, because I know you've come all the way up. I think you're Coral Gables, is that right?
Yeah, I live in Miami Lakes, but actually my daughter lives in Orlando, and I would have come here to visit her anyway, so
all right,
it's a good reason to come by. No apology necessary.
Forget the apology then. All right, so, listen, whatever the court does in this case, it's just tragic, and we're not unsympathetic to what your client's circumstances are. So, all right, we'll be in recess.
Okay.